Is it? Wanted to make sure that we didn't hold anybody out. Okay. Good afternoon, and thank you all for being here today. I'm R.J. Larizza, the elected state attorney for the 7th Judicial Circuit. I asked y'all to be here today to announce what a lot of folks have been asking about. What are we going to do with the 12-year-old and the 14-year-old that have been arrested regarding an incident that occurred in the Enterprise area involving shots fired at law enforcement? Well, in cooperation with our office and the sheriff's office, and looking at the appropriate laws, and also trying to figure out what the appropriate thing to do would be in a case like this. And I got to tell you, it's very disturbing when you're looking at such serious charges with such young folks. But it's the decision of the state attorney's office that the 12-year-old individual will be charged in juvenile court, and that the 14-year-old individual will be charged in adult court. The charges for both individuals are identical, and I'm going to read them to you now. Count 1 is attempted first-degree murder of a law enforcement officer. If they were adults, they would be facing a mandatory life sentence if convicted. But the law for adults, even charged or juveniles, even charged in the adult system, is different because of what we call the Graham-Miller decisions, so that the judge would not necessarily have to impose a life sentence. The second count is burglary of a dwelling while armed with a firearm, which carries a maximum penalty of life imprisonment, but not a mandatory life imprisonment. And the third charge is criminal mischief, felony criminal mischief, because of the damage done to the home of the individual whose home was in close proximity to the location where these two individuals were staying. Now, I do also want to add that while the 14-year-old has been charged as an adult, that the judge has the discretion ultimately to issue juvenile sanctions. Now, this is going to be a long process, folks. There's a lot of work to do in these cases. There's a lot of things to consider. So it's going to take a while to work through the process. I got to tell you, too, there's a lot of things you may want to know today and questions you may ask that I will not be able to answer. I'll do my best to answer what I can under the law. But at the same time, there's a lot of issues that surround individuals that are under the age of 18 and the criminal justice system, and so we have to respect and abide by those statutes and those other rules and requirements. Having said all that, I'd also like to say how much I appreciate the Volusia County Sheriff's Office. I have Division Chief Brian Henderson. He's over the law enforcement operations, and I have the Chief Deputy Joe Gallagher here today. Sheriff Chitwood, I believe, is out of town, and that's why he's not joining us today. But if you've seen, and I suspect most of you have seen the body cam videos of how the officers responded out to this scene. Thank God for the homeowner letting them know that there were weapons in the home and there was ammunition for those weapons. Because otherwise the deputies could have just responded and walked up to that door expecting two juveniles that had broke into a home, and that they were just going to be, it wouldn't be such a violent event. But because of the possibility of the weapons and possible gun violence, the deputies handled it a different way. And I'm sure, like I said, y'all seen the body cam video. What these deputies did, the restraint that they showed, the de-escalation tactics, throwing a phone in the home, trying to get the folks to talk to them, talking to them, asking them to surrender. This went on for several hours before ultimately the sad and unfortunate circumstance of the 14-year-old coming out armed with a shotgun and ultimately being shot because of the threat posed to law enforcement. I mean, they did everything they could do to try and save the violence to escalate. And I just want to commend them for that. And I want to also say that I've chatted with the Secretary of the Department of Juvenile Justice since this incident occurred, And I'm convinced that she and her staff are committed to taking a look at the juvenile system and making attempts to learn something from this event. You know, this is a horrible, disturbing event, that makes you wonder, makes you scratch your head and wonder why it happened. But I'm convinced after talking with Secretary Amayo that they are open to consider ways in which they can address how to deal with kids that commit crimes like this. I mean, the juvenile justice system is well equipped therapeutically for nonviolent offenders, and especially for offenders like when you get into the civil citations. But this is a far cry from a civil citation case. We are blessed and fortunate that none of our law enforcement officers that were out there were harmed. It's sad that the 14-year-old was shot. We're grateful that she's going to survive. And by the way, she will be transported. We have issued an arrest warrant and a transfer order. She will be moved to the Volusia County Branch Jail, where she will be held pending the outcome of these charges. The 12-year-old will continue to be held in juvenile detention here in Volusia County. I've also talked to the Department of Children and Families. In fact, they have created a committee, and one of our own, Kristen DePaula, our managing attorney for juvenile throughout the circuit, is on that committee to work with DCF regarding the housing of juveniles, of minors, and how we can look at this event. We can look at what happened and try to come up with some solutions, try to come up with some positive outcomes in the future, better practices on how to address the very difficult and the very challenging issues of where do you house kids that are in foster care, that are in delinquency status, or come from the dependency court or shelter petitions, and how we can do a better job of that. So I'm grateful at least that there's a dialogue that's been started. So having said all that, I'll open it up for questions, but again, understand it. I may not be able to answer specifically a lot of your questions.
What went into charging the 14-year-old as an adult and the 12-year-old as a juvenile?
Sure. Well, we looked at the facts, the circumstances, and the backgrounds. And I can't go into the backgrounds of the individuals. And age, too. I mean, age plays a part. With the 14-year-old under our current statutory scheme, because of the charges, the state attorney has the discretion to charge. With a 12-year-old, it has to be through an indictment, even with these types of serious charges. But when you look at the overall facts, circumstances, ages, and other considerations, we believe that was the right thing to do.
Mr. Lewis, do you feel there wasn't enough evidence there to charge that or get the indictment against the 12-year-old in this case?
Absolutely not. There's plenty of evidence, in my humble opinion. It's not about evidence. It's about what's the appropriate thing to do. And we decided, and we talked to the law enforcement folks about it, because let's face it, the officers were the ones that were shot at. So we wanted their input on this, but the sheriff's offices they're great partners, and we talked about it, and we believe that this was the appropriate way to handle it. It has nothing to do with the weakness of the case. I'm confident in the charges.
So Sheriff Chitwood's okay with how this is playing out so far?
I've discussed it with Sheriff Chitwood and have not heard any objections at all at this point. Pat?
Reports of the sheriff's office released incident reports indicated that the 14-year-old had been Baker acted at least 10 times in the last 3 years. She also, in her the last 2 reports, both said that she was exhibiting suicidal thoughts or behavior. Did any of that go into consideration as you were deciding whether to charge person or not?
We considered all the information we had, Pat. All the information we had.
Does that give you any concern that she may have mental health issues? She was Baker acted 10 times.
Sure. In their background, in general, not getting specific, is cause for concern and alarm, and it's disturbing. But we believe that putting her charged as an adult doesn't mean that she's ultimately going to be sentenced as an adult. We'll cross that bridge later, Pat, because we have plenty of time to vet both of these kids' backgrounds and vet them not on just police reports, but with experts who can evaluate them and give us expert opinions about really what we're dealing with. That's what I need to know. That's what the prosecution needs to know to ultimately make what we believe will be a fair, reasonable, and defensible position. And so we're working on it.
Can you assure that these two are going to be held in jail-type facilities and not put in children's homes until this goes to trial, or is there any way to do that?
Well, good question. With the 14-year-old, there would have to be a bond hearing, and the judge would have to set a bond that the 14-year-old could make. With the juvenile, it's more complicated because typically you hold them for 21 days. Sometimes you get an extension to 30. But we've talked with the defense counsel, and so my understanding is that we have an agreement or understanding that we'll keep the 12-year-old in juvenile, but that the secure detention will remain. Now, the court will have to do, I think it's every 72 hours, they have to do, once the statutory maximum time period of incarceration passes, they'll do 72-hour status hearings. But look, we believe that both of these folks need to stay in secure detention and get whatever treatments they need, whether it's for psychological or medical conditions, and also to get evaluations for their safety as well as the public safety. So yes, our intent is to keep them incarcerated till these cases are resolved. That's the intent. Yes, ma'am.
Do you have any inclination of how the children might be sentenced based on cases that have come before them of children committing these, controlled crimes?
No, ma'am, and I could tell you I've been in this business since 1980, and this is a new one on me. I mean, this is the first time I've ever seen anything quite like this. But no, it's too early to really speculate about that. I'd be doing a disservice if I even tried. Yes, ma'am.
So, RJ, you're looking at the law here, but as you said, it's the first time you see something like this involving children. So, could you just kind of talk about how you're feeling about this whole thing? The fact that you have to look at charging a 12 and 14-year-old in a shootout with deputies.
Well, look, it gives me no pleasure, and some of you may already be aware, we recently made a decision to charge a 14-year-old in a homicide in St. Johns County, and that's within the last couple of weeks. I've reflected on it. First off, my personal feelings don't play into this. I've got a job to do, and I'm going to do it. But you can't be a human being and not be concerned and disturbed and just bewildered about how this could happen. But like I said, we're lucky that both of these individuals are alive and that we didn't lose any law enforcement. I mean, that's the blessing there. That's going to help us, I think, to resolve this case. Without a homicide, the case is easier to resolve.
And just as a follow-up, you've already said you can only say so much, and you said you decided based on what's appropriate, charging one in juvenile court, one in adult court. But could you just clarify that a little bit? I mean, what is the difference here?
Well, like I said, their ages are one thing. When you're 12 years old and 14, I don't know how many of you have teenagers or have kids, but 2 years can make a lot of difference in a kid's attitude and also in what a kid's experienced. So age, the facts and circumstances of the case, and I'm not going to rehash all of those. You've seen this. You probably have copies of the police reports, so there's information in there that helped us make that decision, and also because we still have the opportunity for the 14-year-old to be treated as a juvenile when it comes to sentencing. That's what people don't always understand. Just the fact that you charge someone as an adult doesn't mean that that's going to be the final outcome. So it gives us time with her as well as with him to get expert opinions about them and to help us to reach a conclusion that I think is fair, equitable, and addresses public safety while at the same time addressing their needs too. Yes, Pat?
I know this is your press conference, you have two deputies.
Yes, sir.
And I just wondered if either of them, this is obviously a very traumatic experience for the deputies involved. They were not only shot at, but then they ended up having to shoot the 14-year-old girl. And I wonder if either of you could speak to how those deputies are doing. I know that they were relieved with pay temporarily.
Yeah, they
pending
were.
investigation, but how are they doing?
They're doing good. We're in contact with them pretty much daily. So right now they're still on administrative leave. We expect them to be back to work probably in the next week.
I think that brings up a good point, though. So we have eight deputies that were involved in this, right? You have deputies that are married. You have deputies that have children, some of which were the same age as these children that they had encountered. So they're going to have to live with that the rest of their lives. No law enforcement officer wants to pull a trigger at all, let alone on children. This is a horrible situation all the way around. But as in the positions that we're in, we're going to have to look out for these deputies for a long period of time. This is unheard of. I was talking earlier, 30-something years of experience. You don't hear about stuff like this. So I do want to thank the state attorney's office, the state attorney and his team. We know this was not an easy decision to come to. But again, the best interest is to ensure the safety of the community, and we think that's what's happening here today.
So the sheriff was also very vocal in last week at the Department of Juvenile Justice. You said that you spoke to the secretary. Sheriff Chipley says he has been, screaming from the rooftops, and there's been no change, that it's been a revolving door, that they're putting kids in these group homes that need to be locked up. Do you really think that this case is going to make a difference, or is this just going to be, oh, we're sorry this happened, that's just what we do?
I hope that this case will make a difference. And I look at problems. Some people say problems or challenges. I call them opportunities. I can't speak for everybody that's going to participate, but if anything could spur some movement at a candid evaluation of how these kids are being placed and how they're being intermingled and how that affects the kids, the community, and public safety. Remember, there's folks that live in this enterprise community as well that are concerned. So I hope so. And we're going to do everything we can from as me as the elected state attorney and our staff and the sheriff's offices to keep this conversation going and talk to the legislators. We've got Representative Renner should take over as Speaker of the House after Representative Sprouse finishes his next term. We've got Senator Wright and our delegations. I think we've got people that'll listen to us. And I think we have folks in decision-making positions with DCF and DJJ that want to help figure out what a better practice would be. So yes. Yes, ma'am.
Do you have any indication that either of the kids understand the gravity of?
Can't comment on that. We don't talk to them. We have no contact with them. That's something that the defense attorneys will explore, and that's something that'll play out in the criminal proceedings. Anything else? Yes, sir.
What's your biggest challenge moving forward with these cases?
The biggest challenge? Well, I think from a proof perspective, evidentiary perspective, there's still things that are out. But I think this is not a case where it's a whodunit or a case where there's been any issues in the way the case was handled. Truly, the bigger challenge, which is an opportunity, is how we treat the folks that have been charged and what ultimately is the appropriate way to resolve them. And that's going to take looking at the law, the facts, and also I think putting some compassion in there as well. But you got to balance public safety with, like I said, the needs of these folks, these individuals. And our priority, law enforcement and the state attorney's office, number one, is you and your family's safety. But we can do that and address, I believe, the needs of these folks that are charged and other folks that get in the criminal justice system. So that, to me, is where the challenge will be, figuring out where that balance hits and what the best resolution would be.
Do you think this will go to speedy trial, or do you think we're going to be waiting on a year on this one?
Typically, they take a while to unfold, but that, again, will be a decision for the defense attorneys. Folks, I appreciate y'all being here today. Thank you, and take care. Okay? All right.